Hello, everyone, and welcome to the August edition of Miller Johnson's Benefits Lunch Break webinar series. Today is August 20th, and my name is Brett Liefbroer, and I'm one of the attorneys in the benefits practice group here at Miller Johnson. And today we also have my colleague Tripp VanderWal, who will be adding commentary and insights as we go along in today's presentation. So this is the third quarter webinar for the 2025 year. And we have one more webinar later this year for Q4, and that's our annual Ask a Benefits Attorney webinar, where anyone can submit questions in advance that you would like to see addressed. And the focus of today's presentation will be the key employee benefit changes under the One Big Beautiful Bill Act. So there were multiple notable changes in this act, not as many as were in the originally proposed act, but there are still some significant changes in this law that employers need to be aware of and may require some updates to plan documents in order to take advantage of some of these changes. So here is a high-level look at the different areas of employee benefits that have been impacted by the Big Beautiful Bill. The primary focus of today's presentation, or the most time, will be spent on the health savings account expansions. We'll also talk about dependent care FSAs, the limitation change there, as well as provisions that affected employer-provided student loan repayment assistance, and some provisions affecting moving expenses and bicycle commuting reimbursements. And lastly, we will explain Trump accounts for children and what employers need to know about those accounts. Starting with HSA expansions, the big headline here is a provision of the Big Beautiful Bill that made some temporary telehealth relief permanent. So before the Big Beautiful Bill, participants in a high deductible health plan generally could not receive benefits under a telehealth arrangement before the satisfaction of their HDHP deductible without jeopardizing their HSA eligibility. Meaning that if that individual received a telehealth appointment and it was not limited to preventive care, that would prevent that individual from being able to make contributions to their HSA or their employer making contributions to their HSA.
I'm going to
Yes.
interject one thing here because this is kind of be a common theme through this HSA expansion. Um, I'm going to touch on HSA eligibility because I'm guessing most folks on the webinar know that the one requirement to be eligible to make or receive contributions to an HSA is you have to be covered by a high deductible health plan. But the often overlooked requirement is the second requirement, that you can't be covered with and I should say with limited exceptions, you can't be covered by another health plan that's not a qualified high deductible health plan. And so the problem with telehealth arrangements is those were generally considered to be health plans. So if they provided benefits without charging the fair market value before an individual satisfied the high deductible health plan deductible, then you were no longer HSA eligible. And again, let me touch on HSA eligible here. That means to make or receive contributions to your HSA. You don't need to be HSA eligible to spend money from your HSA, but that's going to be a permeating theme through this HSA expansion is one, you have to be covered by a qualified high deductible health plan, and two, you can't be covered by a health plan that's not a qualified high deductible health plan. With that, I'll kick it back to you, Brett. Thanks.
Thank you, Tripp. And one big takeaway from the COVID-19 pandemic was that the government did as many things as it could to try to ease life and ease tax burdens on as many people as possible to help people get through the pandemic. And one thing that the government did on a temporary basis was provide that these telehealth arrangements, so remember all the doctor's offices were closed, um, the government passed a temporary law providing that telehealth would not jeopardize HSA eligibility. And that was because most individuals only had access to virtual or telehealth appointments during the pandemic. A lot of people liked that change, and so the safe harbor was temporarily extended multiple times by different laws. And before the big beautiful bill, that temporary relief actually expired on January 1st of this year. But what the big beautiful bill did was make this temporary safe harbor permanent. And not only that, it made the relief effective retroactively back to January 1st of 2025. So even though we operated there in a gap from January 1st through July 4th when the big beautiful bill was signed, there is no gap for this telehealth relief. So individuals now on a permanent basis can have access to telehealth and telehealth appointments without risking jeopardizing their HSA eligibility.
I'll also point out here, Brett, that we have no guidance on what telehealth means. Or obviously telehealth, what they can provide has expanded significantly in the last couple of years. So is there any limitations on that at that point? No. So anything that can, at least at this point, anything that can be provided through telehealth or basically virtually is kind of in bounds here. But we may get some guidance that says, well, this is out of bounds. If this is provided virtually, maybe this won't fit into this exception. So we'll be monitoring that closely.
Thank you, Tripp. Another provision of the big beautiful bill is there are these ACA plans on the individual market, known as bronze and catastrophic plans.
These bronze and catastrophic plans didn't necessarily meet the definition of a qualified high deductible health plan, meaning they weren't HSA eligible. They wouldn't otherwise jeopardize it. They just weren't qualified high deductible health plans. The change made by here, and we can quickly move on from this, is that now they're kind of automatically deemed qualified high deductible health plan, even if the deductible isn't high enough, or even if remember, the other part of a qualified high deductible health plan is there's a separate limit on the maximum out of pocket. Catastrophic plans didn't meet this. This is kind of just a FYI because this is all individual market stuff. Everybody on this webinar, or most people on this webinar, probably here for an employer side group health plans. Just be aware of this. Not going to impact employers really at all.
Yes, thank you, Tripp, for that clarification. So 9 times out of 10, an individual will be enrolled in the employer's high deductible health plan, and will not need to be enrolled in one of these bronze or catastrophic plans. So now we'll talk about direct primary care arrangements and their interaction or impact on HSA eligibility. So as Tripp explained earlier, an individual is not eligible to contribute to an HSA if they're covered by another health plan that is not a qualified high deductible health plan. Before the big beautiful bill, the IRS took the position that a direct primary care arrangement is a disqualifying health plan unless it was limited to preventive care. So under the big beautiful bill, a DPC that meets certain specific requirements that are outlined in the law, including limitations involving the amount of DPC fees that may be charged and the type of medical care provided, is no longer a disqualifying health plan. In other words, access to a DPC before satisfaction of the HDHP deductible will not make the participant ineligible for contributions to an HSA. All of the changes today are effective as of January 2026, other than the telehealth provision that we just spoke about, which is effective in 2025.
And I'll point out here, and Brett's going to take us through the requirements to be what we call an HSA eligible direct primary care arrangement, but direct primary care arrangement is not defined. So it could be any type of arrangement. There's, I've heard a lot of confusion, like, could on-site clinics be a direct primary care arrangement? Theoretically, they could. They would just have to meet the requirements that Brett is going to walk us through. I think the problem with on-site clinics is they often provide services that are outside of the scope of what these requirements under the One Big Beautiful Bill Act limit it to. So if it's an on-site clinic, just because it's called an on-site clinic doesn't mean necessarily that it can't be a DPC arrangement. The arrangement itself just has to meet the requirements that Brett's going to walk us through.
So here are some of those requirements. So a DPC is an arrangement where an individual receives medical care consisting solely of primary care services provided by primary care practitioners, and the sole compensation can only be a fixed periodic fee, such as a per member per month fee. So starting with that fee requirement, the aggregate fees for all DPC arrangements under which the individual is covered may not be more than $150 if the DPC is covering only one individual, and it must be $300 or less if the DPC is covering more than one individual. In future years, these are amounts that will be adjusted for inflation. So what is a primary care practitioner? The BBB defines a primary care practitioner in reference to the Social Security Act, which in turn defines that term as a physician who falls into one of these four primary specialty designations of family medicine, internal medicine, geriatric medicine, or pediatric medicine, or nurse practitioners, clinical nurse specialists, or physician assistants. Primary care services are not explicitly or affirmatively defined in the Big Beautiful Bill.
There's specific exclusions. Primary care does not exclude these three items that you'll take us through.
Yes, these are explicitly listed as not primary care services in the law. And that would be procedures that require the use of general anesthesia. These DPC arrangements cannot provide prescription drugs other than vaccines, and they cannot provide laboratory services not typically administered in an ambulatory primary care setting, which essentially means it's not your routine physical related lab service.
And I'm going to touch on prescription drugs here because it lists it can't provide prescription drugs. That doesn't mean the primary care service provider can't write a script for prescription drugs, just like your primary care doctor would do these days, and you go get it filled elsewhere. That's fine. Is the drug being provided at no cost as part of the DPC arrangement? And obviously, vaccines are fine, but the other thing that's fine, I think it would be rare, is other drugs that are preventative. And the IRS in 2019 gave us a list of some of those drugs. So cholesterol medicine, high blood pressure medicine, those are all preventative medications. And we don't have to get into why those are preventative, but those can still be provided. Now, so then the direct primary care arrangement, if it had access to those drugs, could provide those drugs at no cost to individuals through the arrangement. It's still probably likely that individuals are going to get that through the mail order services from the big PBMs, like anybody that are currently on them and have access to healthcare, generally get already. But I just want to, highlight prescription drugs that are preventative. They can be provided in addition to vaccines through these arrangements at no cost. And the direct primary care provider, even under these, can still write scripts where are filled otherwhere and then covered by the health plan, subject to all the other participant cost sharing requirements.
And as a final point on this slide, we do anticipate there being additional guidance from the IRS on Treasury and the Treasury on what specifically constitutes primary care services. And one more point on DPC fees specifically. Before the Big Beautiful Bill, an HSA could not pay for health insurance. Well, that's still the case. An HSA cannot pay for health insurance without adverse tax consequences. But now, under the Big Beautiful Bill, individuals may use their HSAs to pay for DPC fees on a tax-free basis. In other words, DPC fees are now considered qualified medical expenses for HSA reimbursement purposes. One significant change to dependent care FSAs is an increase in the annual exclusion amount. So under previously existing law, for many, many years, dating back decades, the annual exclusion for dependent care FSA programs was limited to $5,000. That's for married filing jointly or single taxpayers, or $2,500 if married and filing separately. Under the Big Beautiful Bill, starting in 2026, so starting next year, the annual exclusion is increased to $7,500 for married filing jointly or single, or $3,750 if married and filing separately. This is a change that if an employer wants to take advantage of it, the employer probably needs to amend their Section 125 cafeteria plan. Since the previous limit of $5,000 had been in place for so long and was not indexed for inflation, most plans out there probably have this $5,000 amount specifically written into the plan. And if it's not in the plan itself, it was even more likely to be in the SPD, the summary plan description.
Yeah, and I think it may be clear, but I just want to underline it. This is an optional provision. You don't have to increase the limit. You're allowed to. There's no requirement.
Yes, and that is relevant for purposes of this next bullet point, which is the 55% average benefits test. So with the increase in this dependent care FSA limit, it makes it, well, the individuals that are more likely to take advantage of that higher limit and set more money aside into their dependent care FSA are your highly compensated employees. If you
Which are generally those folks that are in the highly compensated employee definition follows that of it's the same definition for your 401k or 403b plan. And right now, and this changes yearly, it's basically owners, and it's generally people that are making more than $155,000 a year.
Yes. So if those are the only folks who are taking advantage of this increased limit, and you were previously an employer who never ran 55% average benefits testing at all, if you implement this change and you never did the testing, now would be a time to evaluate just how many highly compensated employees you have taking advantage of that increased limit. Specifically in comparison to the non-highly compensated employees. And if that testing is failed, there are ways to make corrections, especially before year end. And that typically involves reducing those highly compensated employees' election amounts. But if this was something that was not on your radar before, now is a time to consider it. Under previous law, a provision that allowed employer-provided student loan repayment assistance to be provided on a tax-free basis through the employer's broader educational assistance program. So under existing law, there's a $5,250 exclusion for educational assistance program benefits. There was temporarily a provision that allowed the reimbursement of qualified student loan payments to be treated as qualified educational assistance. But that was a temporary provision that was set to expire on December 31st of this year. Under the BBB, those qualified student loan payments are now permanently included as eligible educational assistance program benefits that can be excluded from individuals' income up to that annual limit of $5,250. Another change is that this $5,250 limit is now also indexed for inflation.
This change came first during COVID, back in 2020, but it was only for 1 year. So I didn't have a lot of clients, or we didn't have a lot of clients, Brett, that were interested in doing it because they're like, if it's going to expire after 1 year, you know, is it worth doing all the work that we're going to have to do? Then with the passage of one of the subsequent COVID bills, maybe it was the CARES Act, they extended it for 5 years. Now this is permanently excluded or extended. So now you can always use an educational assistance plan and include student loan repayment if you want. Again, optional. The other big thing to note here is this 5250, whether you include student loan repayment assistance in your educational assistance plan or not, will be indexed for inflation. So I have a lot of clients that would like to pay more in, for their current employees to go to school, get additional education, additional degrees to either advance them in their current position or to be eligible for new positions. You don't have to do student loan repayment assistance to take advantage of that increased limit as it goes up. So that's kind of a big thing here, because I have a lot of clients that are more generous than the 5250. That's just been stuck in the mud for many, many years. Keep in mind, there's other tactics also to help student loan or your younger employees with student loans repay those, such as amending your 401k plan to allow matching contributions for student loan repayments. But again, and I will also point out, this is qualified student loans, which is difficult to determine. There's no statement you get from the government. Basically, if you used a student loan repayment for anything other than your tuition or your books or like on-campus housing, if you used it for a car payment, to go to the bar on the weekends, it's totally off the table. You can't use this. So employers are never going to be able to know that, and we don't have guidance on how we can verify that. So for my clients that have put this in, we've generally prepared a request form that makes the employee attest that it is a qualified loan, and maybe gives a couple bullet points explaining what that means.
And as a final point, these educational assistance programs need to be in writing. So if an employer wants to take advantage of these qualified student loan repayments and doesn't have that included in its currently existing plan documents, that is a change that would need to be put in by a formal amendment or a restatement of that document. So now I'll address a couple more minor employee benefit related provisions that were in the big beautiful bill. So before the Tax Cuts and Jobs Act employees were able to exclude from income the value of employer-provided moving expense reimbursements. Under the Tax Cuts and Jobs Act, there was a temporary disallowance of those moving expense deductions, and employers were required to include those expense reimbursements as W-2 wages on employees' forms W-2. The Big Beautiful Bill made permanently remove the deduction for those moving expenses and the exclusion of employer-provided qualified moving expense reimbursements. So now that's permanent change. All employer-provided moving expense reimbursements must be included as W-2 wages, and there are only minor exceptions for members of the armed forces and the intelligence community. Also, another somewhat minor benefits change is prior to the Tax Cuts and Jobs Act, employees were able to exclude from income the value of qualified bicycle commuting benefits provided by their employer. That exclusion was temporarily suspended through 2025, and now that suspension is permanent. Bicycle commuting reimbursements may no longer be provided tax-free.
And I would say, again, at the risk of stating the obvious, the clients that I've interacted with, generally that was only an issue if they had offices or facilities located in large cities where there was a lot of people that would potentially bike to work. In the smaller cities and certainly, out in the more rural areas, that's just not a thing that exists.
And the last topic we'll touch on today in the webinar is the creation of new Trump accounts for children. So these are very similar to IRA accounts where employees, and if their employer wishes, the employer can make contributions to an account that must be invested in specific ways and can grow on a tax-free basis until it is distributed in a later year, at which time a portion of those distributions would be considered taxable income. Employees and potentially employers can contribute up to $5,000 in total contributions into these Trump accounts per year. And an employer specifically is able to contribute up to $2,500 to that Trump account per year. And a key point here is that the employer contribution would not be considered gross income for the employee. Whereas if the employee is contributing to these accounts, as of right now and under the law, an employee can only contribute on an after-tax basis. There is a one-time contribution of $1,000 for children born between 2025 and 2028.
And Brett, one thing that's not on that slide is that $1,000 contribution is made by the government, not by the employer or the individual.
Yes, and that is essentially a pilot program. The government will see if these accounts are gaining traction, gaining popularity, and if this $1,000 is incentivizing people to open up these accounts and get them started.
And let me point out, and I think Brett's going to get this on the next slide. This is a little bit of a mix, in my opinion, between an IRA and a 529 plan. So employers aren't going to have to set these up. These are going to be set up by employees on their own. And frankly, if you take my advice for what it's worth, but if you have a kid in these years, you might as well set it up to get the free $1,000. And then employers, as many employers do, you can have payroll deductions to a 529. Now, of course, those come out after tax. So they're net of tax withholdings when they go into that 529. If employers want, not required to, they can say, hey, we can direct tax-free money into your Trump account, which is, again, like an IRA, if you want to do it. but this is not going to require, this is going to be, for employers, this is going to be more of a payroll function than it is a benefits function. There's not anything else, at least at this point, from what we can understand from the bill, for employers to do.
That's right. And employers that do want to start putting money into these accounts, it is the consensus right now that the typical non-discrimination rules would apply to these contributions. So you can't only be putting money in for the children of your highly compensated employees. You need to take care to ensure that the rank and file employees are also receiving contributions. As mentioned, these accounts are similar to IRAs in that they're accounts that are growing on a tax deferred basis. And they also cannot be taken out early. As mentioned in the last bullet point, the distributions are not permitted until the beneficiary attains age 18.
Of course, there's emergency distributions and whatnot, and like a IRA or an HSA, if you need to access it, you can access it even for non-permissible reasons. It's gonna take a, there's gonna be a tax penalty.
And the last point about these accounts is that they need to be invested in eligible investments, and there are some specific requirements for those. Essentially, they need to track, for example, the S&P 500 or another index that's comprised of equity investments in U.S. companies.
So, do we know any major changes to healthcare marketplace that may affect employee enrollment in healthcare plans? Um, I will go ahead and answer this. The only changes is remember under some of the COVID Act, they uncapped the adjusted gross income limitation of which you can qualify for a premium tax credit. Prior to COVID, it had been set if your AGI was over 400% of the federal poverty level, you weren't even eligible for a premium tax credit. There were some bills during COVID that uncapped that. Now, granted, the more you made, the more your premium tax credit went down. So at some point, if you made too much, it wasn't worth it. That cap has been put back in place by the One Big Beautiful Bill Act. I can't remember exactly where it was, but that's to say that potentially that could drive more people that were in the marketplace who are eligible for your company plan to come back on your company plan if they were previously on the marketplace. Next question: Can you allow only a portion of the money from the Trump account to distribute at 18? I think you have to think of a Trump account again like a HSA 529 IRA. Once you put that money in there as an employer, at least what we know right now, it's not yours anymore. It's the employee's. So you can't say, oh, it's not like a 401k where we can say only the employee deferrals are eligible for emergency withdrawals, not the matching account or not the non-elective employer contribution. Once you put that money in the Trump account, it's owned by the employee, or it's owned by the employee on behalf of their beneficiary, and so you can't put any limitations on it. Are Trump accounts available to other children born previously but under 18? They are, as far as we know, but the key is you will not get the $1,000 contribution from the government unless you were born between 2025 and 2028. So, for example, I have a kid who's 10 and I have another one that's 7. I can open Trump accounts for both of them because they're both under 18, but I would not get that government contribution into their Trump account. For student loan reimbursement, if a student loan is used for both tuition and room and board, can they be compensated for the portion that was used for tuition if they could substantiate that? Yes, the student loan has to be a qualified student loan, and there's restrictions on that. And it can be used for tuition and it can be used for room and board for on-campus housing. And then if you're off-campus housing, there's much more restrictions about whether it's reasonable fair market value for rental area rates in the area. That's why if anyone on the call has been recently paying or has repaid or is currently repaying student loans, you will get a 1098-T as in Tripp at the end of the year and tell you how much tuition you paid and said, if this was a qualified loan, you may be able to deduct this or qualify for a deduction on your tax return. The government's not going to tell you, because I will tell you, for me, like when I went to law school, the government paid the law school directly, and then the excess amount went into my bank account, and then I could use it for whatever I wanted. So that's why it's really difficult for an employer to understand whether it's a qualified student loan or not, because we don't know that. If it all went to the university for tuition, that's fine. If it covered room and board for on-campus room and board, that's fine. If they start moving off of campus, then like how I lived in law school, then the rules become much, much more tricky, which is why we advise for that attestation. As long as they sign the attestation for what we know right now without any guidance, that's probably sufficient, unless you know that attestation is not truthful. Brett, it looks like we've gotten all through the questions. So thanks everyone for joining us. And if you have any other questions, feel free to either email myself or Brett, and have a wonderful rest of the week. Thanks, everyone.
Thanks, everyone.